Sir, you're not audible.
I am audible now?
Yes, 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 right now.
Yes, okay. Yes. Yes. Now, in the last lecture, we were on the point, the the changes which were made. तो यहाँ पे कुछ हो गया. The changes which were made. क्या हो गया?
सर वो किसी का कॉल आ रहा था. मैं
यहाँ पे कॉल आ रहा था.
हाँ सर, एक मिनट.
इसीलिए तुम बैठे हो इधर.
हाँ सर, you have got to go.
Where is the arrest provision? हम लोग ले लेते. तुम इधर बैठ जाओ. लिख करो. No problem. You can see. No problem. She can come. She can assist me. No problem. करो. बैठो बैठ चलेगा. What is wrong in it? Yeah. Where is the on the mic? ये बराबर हो गया?
Yes, sir, you are audible.
Can we proceed now? Yeah.
Yes, sir. Yes, sir.
Yeah. Good evening, everybody. Now we'll continue the lecture from the point where we left yesterday, in the last lecture. So we gave the salient features and the changes made by the Parliament in the new act, in the new Bnss. After giving you the narration of act, salient features, then we began discussing step by step the procedure which is sought to be done under the act. So, because I inform you that here we are not going to discuss section wise, because as a lawyer, when you're practicing lawyer in the court of law, section wise we don't proceed. It is the stages wise. So I mentioned to you that the starting point, a criminal law is set into motion by the presentation of a document called First Information Report under the CRPC, which was originally under Section 154 CRPC 1973. Now it is under Section 173 to 196 of the Bnss Act. BNSS, that is Bharatiya Nyaya Bharatiya Nagrik Sanitya Suricha 2023. Yes. Now the notable changes which are made by the Parliament are: number one, the First Information Report can be recorded through electronic communication. Number two, zero FIR, namely, there is no requirement that the FIR must be registered in a place where the crime took place. FIR can be registered in a place which is nearest to you in the police station. It is the duty of the police officer to transfer it here. Then another notable change which was made in the provisions of relating to FIR is holding a preliminary inquiry, which we suggested, which we discussed last time, in respect of offences which are punishable between 3 and 7 years, possibly in the line with the judgment of the Supreme Court in Lalita Kumari versus State of UP. Then provision is made, we discuss here, that the police officer must furnish the copy of the FIR not only to the informant and also to the victim. This has been introduced for the first time. No sooner the new section 174 mandates that here the officer must forward the case papers to the nearest magistrate, that is 170 4. Now, under the provisions of the new act here, subsection 4 of 175, magistrate empowered under section 2110 may receiving complaint against may pass the orders that here the police must comply with the various provision, and audio video recording electronic data is made compulsory under the provisions of section 176 of the new act, which was earlier 157 of the CRPC. Now, forensic facility has been now newly introduced under the provisions of section 176(3). On receipt of every information relating to the commission of offences which is made punishable for 7 years or more, offences which are punishable for 7 years or more, the officer in charge of a police station shall from the very first day collect the forensic report crime through the medium of electronic data, which requirement was not there in the earlier code now. Now, the non-compliance of the requirement is given under section 172 of the act here in the matter. Now, this will probably take, so there must be a inquiry under a preliminary inquiry in respect of offences between 3 and 7 years. And there must be forensic facility data must be collected by the police officer in respect of offences which are punishable for more than 7 years is the next requirement here. Then under section 179 of the CRPC of the Bnss, which is equal to section 160 of the old CRPC, the police powers for examining witnesses, famous one. Now there is a new subclause has been added here that the police need not, a male person under the age of 15 years and above the age of 60 years and a woman mentally and physically disabled person need not attend the police station. That is here 65 years of the age which has been spent. They are clarified now. Now the Bnss section 179 extends exemption to the person with acute illness. But at the same time, it makes a proviso that if these people want to go to the police station, there is no embargo. You have a right to go, it will not be objected to. Yes. So audio under 187.7, again, the audio, video, electronic recording is made compulsory in the matter. Now, to which a new section has been added in the proviso, which says that a proviso below 191 provide that the accused is not in custody, the police officer shall take security from such person from the appearance before the magistrate to whom such report is forwarded and shall not refuse to accept the same, so and so. Now, this provision, you will recall that here, 170 of the CRPC, old CRPC, 169 CRPC says that here, the police officer, after completing the investigation, if he is of the opinion that there is no sufficient evidence, he can discharge the accused. He may grant the accused a bail and he has to submit the report to the police officer. No case is made out. 169, you know that B summary cases, A summary cases. So these are the summary cases are under the police regulations, police rules under the Bombay Police Act. In each state has got rules and regulation. They are given these categories. What is B summary, A summary, and C summary. Now the CRPC does not. CRPC old section is section 169, when the power of the police officer to discharge the accused person with the permission of the magistrate, placing on record that the material which has been collected does not justify prosecution of the accused. Now, the present section is section 170 CRPC. Yes. Sorry. And the present section is the present section in CRPC 190 it is. Please note that 190 is the section where the new proviso has been added. The police officer earlier used to send it because the police cannot, the magistrate cannot take cognizance of the accused unless he is in custody. There are several judgments to that point. Unless he is in custody, he cannot be transmitted. So under 170, he cannot try. Now under 190, the legislature makes a special law that the police officer shall take security from the person. In case he is not on bail, he has to give security. In many cases, there are under trials. After investigation, the police officer will feel that here, though the provision of bail was there, he has not been availed, and for reasons of poverty or A reason, B reason, he has not applied for a bail. Then the police officer, after investigation, he comes to know that here no case is made out or a case is made out, but before transmission, he has to securing the attendance of the accused person. He must take security from such a person. This was not the case earlier in section 169 and 170 of the old CRPC. So this is a new section which has been added. Now, as of you know that here, the investigation time limit has been fixed for completion of the investigation under 193 subclause 9, that within 90 days has been extended. 90 days has been extended, and intimation must be given to the victim that is showing the progress, and also information should be provided to the informer as well as the victim through electronic means. So that is 195 and make changes in the provision, provide that no male person under the age of 15 years, we have discussed this provision, and mentally sound person. Then we come to know that here, thereafter we discuss the provision relating to the remand procedure under section 167 CRPC, now 187 of the Bnss. So the moment the investigations are completed, now investigation also, because within 24 hours you cannot complete the investigation. And if the police officer who has brought the accused person before the magistrate within 24 hours, the police officer, the accused, there are two remedies open to the magistrate, judicial magistrate. Number one, either he can grant the custody of the police, which is known as a police custody, which is normally kept which is normally cannot exceed more than 15 days maximum period. Or he may say that here, tell the police officer, you don't need even 15 days custody. I am giving you 1 or 2 days custody, police custody, so that you complete the investigation and submit the report. Now, this particular mandate of the magistrate under section 187 of the new act is to facilitate that the fundamental right of the accused under Article 21 are not violated. He is not subjected to torture by the police officer. You know that this is the period when the accused is kept in the custody of the police officer, the maximum torture take place, where the Supreme Court in several cases had laid down the guidelines. For example, one of the judgment which was shared on the net is give me the list of the judgment. That judgment we have shared, please go through the judgments. For example, I will briefly run through number one, that is guidelines laid down by the Honorable Supreme Court in Basu's case, DK Basu's case. The grounds of arrest must be furnished to the accused person. He cannot be kept in custody if in inordinate period. Then the guidelines also laid down by the Honorable Supreme Court in the case of Jogendra Kumar's case, whether it is there or not, I do not know. Jogendra Kumar versus State of UP. That was the earlier case of the year 1994. where the guidelines were laid down. Joginder Kumar's case was a young advocate. After passing law, he was summoned by the Punjab police. And see, the police officer summoned him, and 3, 4, 5 days के लिए पता नहीं क्या मसूरी में what happened. The police. Then his brother went to the police station to find out the whereabouts. Where is my brother? Your brother is even arrested. I want to apply for a bail. The police officer doesn't give any response. Then they don't even tell anything, because the grounds are also not furnished within 24 hours are not produced as per the mandate under Article 22 and Section 57 of the CRPC. Then the gentleman files a habeas corpus petition before the Honorable Supreme Court, where the guidelines came to be laid down. You cannot keep anybody in the jail for more than 24 hours or for 5 days without giving intimation. So Joginder Kumar's versus State of UP is one of the early judgments where the arrest guidelines were given. Police, what are the I think whether this is that is the report of the National Police Commission at page number 32 of the judgment. That is, arrest during investigation may be considered justified in other following circumstances, namely, there are involves a grave offences like murder, dacoity, robbery, rape, necessary to arrest so and so. Then accused is likely to abscond or evade due process of law. Then the accused is given violent behavior likely to commit further offences. The accused is a habitual offender. So these are the circumstances where even the courts, the guideline laid down by the National Police Commission, when it comes to handcuffing of the accused, it was a very normal for any police station to immediately arrest ho gaya. Maybe the punishment may be 1 year, 6 months, 3 months, 2 years. He is arrested. So the guidelines were laid down by the Supreme Court in the Joginder Kumar's case, subsequently in the case of D.K. Basu versus State of Punjab. That judgment, that we have shared it on the group. 96, one of the leading judgment, a letter written by Basu, was a practicing lawyer in Delhi, who was a member of, is a custodial torture. That is a judgment relating to custodial torture. The putting handcuffing an accused is a humiliation, in a violation of his life and liberty, and the Supreme Court has beautifully laid down the guidelines in that matter. Then that there are one more judgment was there of the Supreme Court. That is Sunil Batra was a Delhi administration, was a case that is reported in AIR 1980 Supreme Court, page number 1579, where Justice Krishna Iyer, Justice Pathak, and Justice Chinnappa Reddy's bench, they laid down the administration. Here, this very unfortunate case, Sunil Batra was a convict. He was serving death sentence. Third-degree treatment was given to him. He wrote a letter to the Supreme Court, placing on record that year that he has sustained serious anal injuries. कितनी बेहुरमती से उनको बेचारे को तंग किए देखो. It was reported that an iron rod has been driven in his anus. That is the brutality of the police officer. The Supreme Court laid down the guideline in that matter and suspended the police officers. That Sunil Batra was the Delhi administration. There also guidelines were laid down. Then another case which that here, the leading case with regard to handcuffing, Prem Shankar Shukla was the Delhi administration. That is AIR 1980 Supreme Court, page number 1535, where the bench of the Supreme Court, it was also a leading judgment. Justice Krishna Iyer's bench, and Justice Pathak and Justice Chinnappa Reddy. They appointed Dr. Chitle and Justice Mukul Mudgul when he was the practicing advocate. He was a junior of Justice Justice Chitle. That a letter written by one of the under trials, that here I have been handcuffed. Then he says, points out, as per the Delhi administration and as per the judgment of the Supreme Court in earlier cases, I should be treated differently. I belong to a class of prisoners. He brought about the classification here. I should be treated differently. That para with regard to classification is done by the Supreme Court, mentioning that there is no such classification. Of course, in many police manuals in various states, they have mentioned in what cases handcuffing should be done. In Punjab and many other cases, if the offense is punishable for more than 3 years, handcuffing is compulsory. The Supreme Court struck down that provision of the Punjab in this matter. Placing a record that it is illegal. Justice Pathak also wrote a concurring judgment in that regard. That's a landmark judgment. Then you also must be knowing that here the Nadiad magistrate's case, give it to me that the Nadiad magistrate's case, judicial administration, Judicial Service Association versus State of Gujarat. This is a very sorry state of affair. Here the judicial magistrate N.L. Patel was a very honest magistrate. He was disciplinarian and strict person. But he was very unhappy with the fact that the police in Gujarat, especially in Nadiad district, were not discharging their duties in the matter of effecting writ of summons or executing warrants, and resulting in the delay of the cases. So he complained about the police administration to seniors. That was not appreciated by the police. For some reason, one fine day, the police inspector of the area, Mr. S.R. Sharma, invited the magistrate, requesting him to come as a chief guest to the police station and give a little sermon to the police staff. They will be happy, and give him some tips as to how to improve the administration and how they should effectively work. Under the guise of inviting him as a chief guest, this gentleman, the police officer, made the magistrate consume liquor under duress, handcuffed him, paraded him in the street of Madhyar. Because an act of retaliation, why did you complain? Now that matter, you must be aware of that here, gathered newspaper attention. Then the Supreme Court take a judicial notice of the matter that the Delhi Judicial Services file a petition in the High Court for suspension of the police officer and for relief to the magistrate in the matter. So that there the Supreme Court also criticized the handcuffing of the magistrate or any person in the matter. So despite that, here now in Shukla's case, one of the observation of the court is that here merely because a person is charged with grave offenses, he cannot be handcuffed. He may be very quiet, he may be well behaved, he may be docile or even timid. Merely because the offense is serious, the inferences of escaping proneness or desperate character does not follow. Many other conditions mentioned in the police manual are totally incongruous and must fall unlawful. That is the observation of the Supreme Court in Prem Shankar Shukla versus Delhi Administration, 1980 Supreme Court. Now, unfortunately, the Parliament has not seriously taken this into consideration. And of course, they have maintained the clause with regard to handcuffing of the criminal under the provisions of the new. If anyone want to switch on to the camera and ask question, please do that. I will answer the questions on this. Yes. Where are my notes here? So that is the topic here. Yes. Now the provision relating to handcuffing, you will see in the new act, section 40, section 43 of the Bnss. The earlier section was 46 CRPC. Just open section 46 old. If you see section 46, we will see the changes. What are the changes they have brought? Just 46. Now, old 46 says that arrest how it is made. Now, what are the changes which are brought about? See, in making an arrest, the police officer, other person making shall actually touch, confine the body of a person to be arrested unless so and so. Provided there was a women to be arrested, unless circumstances, intimation, so and so is given here. Then handcuffing का provision निकालिए इसके अंदर. Now, when you see the new act, section 43, section 43 makes certain changes. Subclause 3 provide the police officer may, keeping in view the nature and gravity of the offense, use handcuff while making the arrest of a person or while producing such a person before the court who is a habitual or repeat offender or who escaped from the custody or who has committed offense of organized crime, terrorist act, drug related crime, or illegal possession of the arms and ammunition, murder, rape, acid attack, counterfeiting of coins, currency note, trafficking, sexual offenses against children and against the state. So they have not taken into consideration the Supreme Court's observation in Prem Shankar Shukla's case, that is which I just now read out to you. Merely because a person is charged with a grave offense, he cannot be handcuffed. He may be very quiet, he may be well behaved, docile or even timid. So gravity of the offense is not the criteria for handcuffing. It differs from each person to person, each accused. Somebody may be very aggressive. Somebody may be very cunning, wanting to evade arrest. Yes, you are justified. So that provision is, according to me, the Parliament should have followed the Supreme Court's observation in Prem Shankar Shukla's versus Delhi administration and D.K. Basu's case. So that is not done, unfortunately. Discretion is given to the police officer to do that. So ये हो गया arrest का provision. Now after arrest के बाद, then the other provision relating to what are the arrest होने के बाद, then how the what are the rights of the person, arrested person we were dealing with here. Section, the provision relating to 43 to हो गया अभी. Then the new changes which are brought, that here the person who is sought to be arrested even by a private person, he should be brought to the police station within 6 hours. They have specified it here under section 40, but there is no provision if he doesn't bring. What are the consequences? Okay. Then the police officer has a power to rearrest. Then 43(3) makes a provision for handcuffing, which is again, with due respect, in violation of the Supreme Court judgment in Prem Shankar Shukla's case and D.K. Basu's case, as well as several judgments, even the judgment of the leading Supreme Court judgment in Husainara Khatu's case, where the dignity of a human being is very important. That should have been followed. But according to me, the amendment is slightly in favor of the police officer. This amendment with regard to arrest and power, of course, no doubt, there are good features that FIR should be given to the victim, inquiry should be held. These are very, and zero FIR. These are very laudable features. But empowering the police officers and handcuffing the accused person, it doesn't augur well for the administration of justice. Then, yes. Then, of course, it is good that the under the new act here, the videography is made compulsory. Now, identification of a parade of the person, no identity of the person. The earlier section was section 54A. The earlier section 54A. Now it is Bnss ke andar 54. The present 54. Here, identifying a person, the arrested person mentally or physically disabled, the identification process should be videographed, so that there are no complaints, there are no allegations that the police has misused and abused, or it is in fact by virtue of any complaints going there. 54 BNSS modifies the above provision, requiring the identification process to be audio, video, and electronic means. It should be videography of the identity of the parade. So identification of parade is very important. Such evidence is now led under the provisions of Section 9 of the Indian Evidence Act, and also there is a act called Identification of Parade Act here. We all know that here. Then under Section 58 of the present act, which was earlier 57, that is a person arrested not to be detained more than 24 hours. Now earlier he could be brought before, arrested to the magistrate. Now in the present act here, magistrate whether having jurisdiction or not. So that is irrespective of the fact that he has jurisdiction, no jurisdiction. That means it is not necessary that he should be brought before a judicial magistrate. Even if he is an executive magistrate, probably that's what it means here. See that here? Any money magistrate, whether having jurisdiction or not. Because under the present act, the DCP, police officer, is also designated with the powers of a magistrate. That is the meaning here. Then, of course, all summons and all to be given by the electronic means, in the electronic means, which is also a very good provision. Now the word telegram, which was appearing in the earlier section 91, now it is section 94 has been deleted, because the telegrams have been deleted. All of you know, telegraphic authority is now deleted, so that is not very important here. Yeah, then section 105 relating to search is a new provision. Now there was no corresponding requirement of this section. Now 105 of the new act provide that the process of conducting search of a place or taking possession of any property, article, things, including preparation of a thing seized, such seizure, signing of the list, shall be recorded through audio, video, electronic means. Interesting. Now that is like how you make the panchanamas. These were the earlier panchanamas under 100 section 100, 102, 103 is the provision where the police officer makes a panchanama. Now it should be videographed compulsorily. It should be district magistrate or subdivisional magistrate or judicial magistrate or the first class. So earlier there was no, this provision was not there in the old act. That is when you see the old act relating to the provisions relating to search and seizure, starting from section 92 onwards, 100 and 101, 103 CRPC. Then attachment, there is a section 107 is also new provision under the new act during investigation, which provides a lengthy procedure as to how the seizure can take place. There's a fantastic powers have been conferred upon the police and the magistrate. The seizure of the property, judicial magistrate can pass it here, and ex parte orders can be passed. Ex parte order first time, 14 days notice to be given by the magistrate, and ex parte orders can be passed if the property is sought to be of the accused person or any person, property which has been involved in the commission of the crime is sought to be done here. That is section 107, subclause 6. You can say that here. Yes. Yeah. Yes. I'm coming. Now, after having done with the basic requirement, then the next topic is from the continuation of what we did last time. That is the remand period. Remand. That is earlier section 167. Now the present section with regard to remand. Remand. Now, what are the changes which are made? I will take you through. That is section 167 earlier act. Yeah. Yes. 167 CRPC provided earlier that if the investigation is not completed within 24 hours, the magistrate, the police officer has to bring the accused person to the magistrate, judicial magistrate. Now here the expression used is, they are not used the word judicial magistrate. You please see that here. It is something disturbing according to me. Which magistrate then? They are not used the word judicial magistrate. Earlier section uses the word, if I'm not mistaken, if you open your 167 CRPC, one judicial, in the first 167 के अंदर, he shall be forthwith transmit to the nearest judicial magistrate. Now this section is now this new section I am pointing out to you is under the new Bnss section 172. No, sorry, not 172, 187.2. Will you just open 187.2 of the Bnss? This is a very material provision because this is the fundamental right of the accused is involved at this moment here. Whether he should be released on bail or whether he should suffer in jail, whether he should come on bail. That is 187, 187.2. I will just briefly run through and comment upon the section 101, 187. Now, will you kindly see that here 187 ke andar, they have not used that. He should be 187 mein, he should be brought before the nearest magistrate. So they excluded the word judicial magistrate. Now it can also he can also be brought before the superintendent of police or a magistrate, the collector of the area who is also a magistrate. It has to be clarified. It is not done. Basically, under the scheme of the CRPC, it is the judicial magistrate first class and second class. Formerly, it was cities like Bombay, Calcutta, Madras, Ahmedabad, Delhi. It was the metropolitan magistrate. It was the metropolitan magistrate who are the person trying, and in places like district places or remote places, it was the judicial magistrate first class, second class. Now they have removed the word judicial magistrate, only magistrate has been used. Then subclause 2 ke andar, the earlier provision was that here again the magistrate to whom the accused person is forwarded under this respective provision, whether he is released or not on bail, cancel from time to time, he can be granted police custody for 15 days in a whole. Then again it said that or in parts at any time during the initial 40 days or 60 days. Now this is a newly added amendment to the provisions of section 187, which was not existing earlier in section 167(2). Or if I fail to understand, that means the person arrested can be kept in custody till the period of 90 days. That is what you had assumed. The legislature has to clarify this, or there should be some Supreme Court mandate here. Please clarify this here. There is no clarification here. If you read sub 187 subclause 2, magistrate is given power to police that here, not exceeding 15 days in a whole bolte on or in parts at any time during the initial 45 days, 40 days, or 60 days out of the detention period, 60 days or 90 days as the case may be, as per subsection 3. This is a gray area in the legislation. I have not been able to understand this very clearly, whether the present section is seeking to say that here he should be kept in jail for 15 days or 90 days. This photograph is coming. Yeah. So this has to be clarified here. Now, subsection 3 says that magistrate may authorize the detention of the person beyond the period of 15 days. Now see that here. But no magistrate shall authorize. Beyond 15 days, he can keep him in custody. Now, which custody? Whether it's a police custody, judicial custody is not clarified here. Then 90 days maximum death penalty, 60 days. Then subsection 4 says now they will be audio, video, electronic means to be done here. Then the second proviso also adds certain words which were not initially there, or some of them have been retained. So the disturbing scenario in section 187 is subsection 2. Subsection 2 speaks that here he can be kept in custody for 15 days or in parts 40 days, 60 days, 90 days. That means the police remand can be granted up to 90 days. There are more powers given to police officer in this regard. Please note that the remand is not easy. Yeah. So after the remand, during the period of remand, a defense lawyer, the police officer, the public prosecutor will say that I want custody further because I need to examine some more witnesses. Some witnesses need for confrontation. There may be more than two or more person being tried together. A joint trial, maybe trial of conspiracy committed in Bombay, Calcutta, Madras. It's a delicate matter. So the police officer can always say that I want to confront the witnesses from Calcutta with the accused person who was arrested in Bombay, and I also want to confront him the witnesses who are brought from Delhi or Bangalore. So in that way, they will press that here maximum time be granted to be 60 days or 90 days time. So the magistrates are in their discretion. A heavy judicial discretion is granted to the magistrate in this regard. All of you know that here. Magistrate has got maximum powers whether to grant or not. Now, once the remand procedure, so we learned your first information report ho gaya. First information report ke baad, then within 24 hours the accused is brought before the magistrate. Then provisions of section 167 earlier code and now the provisions of section 187 are now exhausted. 187 relating to remand. Please note that it's a very, very crucial. Now, uske baad, the right of the accused also starts now. That is to make a bail application. Okay. To make a bail application. 479 here. Earlier section was 430, 436, starting with 436. Bail offense bail in bailable cases. Open this. 436 खोलिए. 436 CRPC old section provision relating to bail bonds. The earlier chapter was 33 section 436, isn't it? 436. That is the first. So I will just give you. There are three types of powers. Please hold it. Yeah. Now your powers with regard to bail under the present provisions are section 479. The college here 479. Now sections have been taken a somersault. See, provision relating to bail and bail bond are chapter 2035 in the new act. Now 478 deals with cases of bail. (479) of the present CRPC, the new CPC, that is a Bharatiya Nagrik Suraksha Sanhita 2023, provides maximum period for which under trial can be detained under 479. That is 1/2 of the maximum period. That is, this is a section equivalent to the earlier section 436A. 436A under the old act, bail can be granted to the accused person once he completes one-half of the maximum sentence. One-half of the maximum sentence. Yes. Now the present act, now the earlier act section 436A gave concession that any person for any offenses arrested, but whereas under the new act, such concession can be availed he should be a first-time offender. See the word here. The provisions of section 479. 479 says that here, if you want to invoke the provisions of bail after spending 1/2 of the maximum period, you should be a first-time offender. Earlier, this was not there. And who has not been convicted any offenses in the past. That means you must be a Mr. Clean in the past. And you can be released on bond by the court, extending the 1/3 of the maximum period. So this is the change which has been brought about in the section, new section. Now give me that.
But sir, may I ask one question? Let's say you have completed that 1/2 of period and you are released on bail. But does the period in which you are out on bail continue against your sentence, or is it or is your sentence paused?
Your
And
trial
once you
will
go
go
back
on.
to
This is the bail is granted to you during the pendency of a trial.
okay, yeah.
It doesn't mean that the bail you are out, आपको trial नहीं face करना पड़ेगा. This is
Okay,
only to facilitate that you can do your day-to-day activities and appear before the court in time. This is an interlocutory application released to you during the pendency of a trial. Because half
Thank
the
you, sir.
trial, the parliament has thought it fit, having relied upon the earlier Supreme Court judgment, the matters are not being taken up. The courts are overburdened. So why should a man be kept in jail for lifelong? One of the illustration, this audio affair about the Husainara Khatun's case, 79, where the Supreme Court said that here, people have completed more than 3 years, 4 years, 5 years, still they are in jail. That judgment we refer to, see, Husainara Khanun versus State Secretary, State of Bihar. That is AIR 1979, Supreme Court, page number 1369. Justice Bhagwati has brought on record beautifully. He said the mandate of section 339A is made compulsory. Directive principles of state policy stating that here the accused should be given a free advocate. For want of having no advocates, they are not able to avail the bail condition. It is now the mandatory duty of the magistrate to ask a person, do you have an advocate? If you don't have an advocate, I will give you one. No accused should go unrepresented. That is the mandate of law. Despite the fact that there is that was the provision made in Husainara Khanun's case. There is Article 39A. We refer to all of you know that here. Yeah. Then next it says that here the change which is brought about, important change, section 482. Now 482, old section is 360. No. Apprehending arrest. Direction to grant bail of a person apprehending arrest. Yes, there is an anticipatory bail requirement. Yeah, sorry, before I'll just cover these two, wait. 478 may be covered the fact that 436 and 36A के अंदर first time offenders and persons who are in bailable offences, the police officer himself has power to grant bail, or the court can. He cannot be kept in jail. That is the mandate of section 478, and the whole section is 436. Bailable offences, police officer can himself give a bail, and
Sir,
the police officer. Yeah. Anybody want to ask a question?
Yes, sir. Related to section 438, in case of a bailable offense,
Yes. Then
if the accused does not appear in a
for example, then in cases 480, when bail may be taken in cases of non-bailable offences. Now this is akin to old section 437. So 437 are cases, that is 480. So they mean 478 starts with a case when any person in other than a person accused of non-bailable offences. That means 437 powers are exercised only in respect of cases which are bailable offences. Actually, a person need not bother to go to the magistrate for a bail under the chapter under section 478, which was earlier section 436. The police officer should grant the bail. Why the person has to go to the magistrate? But sometimes the magistrate, the police officers, many times they do not grant bail. Forget about granting bail. Even if the offense is punishable for 3 months, 6 months, they are kept in jail for 3 years, 4 years, 5 years. That horrible state of affair came to light, was brought to the attention of the court in Husainara Khatun's case, that you must go through minutely. It's a very landmark judgment. So 438 is applicable only. The police officer can take a bond. So you know that the Supreme Court in person is not in a position to take a bail on account of poverty, on account of financial condition. The court said that personal bond is sufficient. Examine the person, he is able to come, and you can take a personal bond. And you need not have a local sureties. Sureties may be from the Gaon, from any other person. That is what the Justice Krishna here in Motiram's case held it here in the year 1978. Local surety is not mandatory. And cash bail also not mandatory. It has become a fashion these days. The cash bail leke aao, then local surety laiye. That is very, creating obstacles in the light of in the liberty of a person. Then 478 padli humne. 479 is equal to section 3, the earlier section 436A. So the difference is that here first time offenders can only make the application, which is very rather unfortunate. But second time offender can also make it. Then the law says that here the other section is maintained, public prosecutor must be given notice. Then 480 are the cases where the magistrate grants bail in non-bailable offences. This is equal to section 437. Yes. Now, exception is that even if a charge of a murder, punishable serious offences, normally the bail is not easily given, except in the case of a child or a woman or a sick and infirm person. A child now has been defined as a person of 18 years under the Indian Penal Code, that is the Bharatiya Bnss. So that is the new exception which has been added here. Third proviso, section 480:30, the third proviso says that here. No person shall, if the offence alleged to have been committed by him, be punishable with death, imprisonment, or life imprisonment, 7 years or more, release on bail by the court under the subsection without giving notice. Now the first proviso says that court may direct the person referred to clause 1 be released if such person is child, women, or so magistrate normally does not have jurisdiction to grant a bail, and normally in cases which are punishable with death or life imprisonment. But exception is made in the case of a child, women, and a sick person. Now, in the city of Bombay, it is a fashion we have seen in many cases. Magistrate will say, I can only try, I am not entitled to try cases punishable with death, life imprisonment. So I will not grant you bail. The magistrate is not correct. So you have to see the legislative mandate which has carved out exception in the first proviso. The magistrate assumes jurisdiction. So that is section 430. Before a court other than a high court or a court of session. 430 says that. That means the power of the judicial magistrate first class, power of judicial magistrate second class. Please note that here they are not specifically used this word. From 180 subclause 1 say it says that here where a person accused of, suspected of commission of any non-bailable offence, arrested or detained without warrant by any officer in charge of a police station appears brought before the court other than high court or session court, he may be released on bail. That is, he is brought before the judicial magistrate first class, a judicial magistrate second class. Only two types of classes of judicial magistrate. Then such a person shall not be released if there appears to be a ground of believing that he is guilty of offense punishable with death or imprisonment life. So death punishment ke liye magistrate has no power to grant bail even for life imprisonment, because we learned that here magistrate cannot try offenses more than 7 years. That may be different. Then B subsection 2 says he shall not be released if such a person if offense is cognizable and has been previously convicted of the offense punishable with death, imprisonment for life for 7 years or more. So even if a person has been arrested earlier in offenses relating to 7 years, say for example, he has committed the act of cheating, impersonation, or breach of trust, whatever may be, 7 years punishment is there. He cannot be granted bail by the magistrate. The proviso says, first proviso, magistrate may direct the person, refer to clause 1 and 2, release the bail, child, woman, or a sick person. So the magistrate should know that he has got power to arrest a child, women, and a senior citizen, a sick person. A sick person, even if they are involved in the commission of the offense of murder or life imprisonment. That is the case here. The second proviso, direct that refer to in clause release and bail if satisfied, just and proper to do so. The magistrate has to record reason for that. Why is he granting the bail? Of course, recording the ground that he is a child below the age of 18 years of age, that the offense, the accused is a woman, or that the accused person is a sick person, medical record is brought, shown to me, I'm satisfied, he is suffering from chronic diseases, ABC, that discretion is given to the magistrate to grant bail and record reasoning. The second proviso says that here, maybe the fact that an accused person may be required for being identified by witnesses during investigation for a police custody beyond first 15 days shall not be sufficient ground for refusing the ground if he is otherwise entitled to release. So the police officer and public prosecutor cannot tell the magistrate that accused has not been so far identified. So identification parade is required to be held, as you know that here. That is now required to be videographed. That itself is not a ground to deny the bail, because the liberty, life and liberty of a person under Article 21 will be violated if he is kept in behind the bars. That is the mandate of law, which says that the court should be liberal in granting bail, which is bail. The Supreme Court says in the case, second case, then in this case, judgment number 2. In this case, that is, I have given refer to State of Rajasthan versus Balchand Balia's case. Balchand AIR 1977, Supreme Court, page number 2447, where the Supreme Court says in paragraph number, when you see Justice Makwana's observation, the basic rule may perhaps be tersely put, bail and not jail. That is the law which has been laid down by the Supreme Court from way back. So the prosecution cannot take up cudgels saying that here identification parade has not taken place. So please, you may grant for the time an application for bail may be rejected. That is not the criteria. Okay. Then 480 dealt with the non-bailable offences. Then next important section is 482, that is equal to earlier section anticipatory bail 438. Now this section has gone substantial changes. Now substantial changes. The earlier section mandated that open old section open kare. Under section 438 CRPC, there were a lot of conditions. The old conditions, such as the nature and gravity of the accusation, they are omitted. Then the accidents of the application, including the fact whether he has previously undergone imprisonment conviction, is also omitted. Then the possibility of the applicant being fleeing from justice is omitted. Then accusation has been made with the object of injuring or humiliating the applicant is also omitted. But a wide discretion is given to the session and high court judges. Anticipatory bail application can only be made before the court of sessions and the high court, but the magistrate, like judicial magistrate, first class, second class, they have no jurisdiction. It is clearly mentioned that here court of sessions and the high court and the court of session. So a wide discretion is given. The conditions which are enumerated in section 482 subclause 2 are number 1, subclause 2 में check किया. The high court or a session court make direction under subsection 1 may include such condition. Number 1, condition that a person shall make himself available for interrogation by the police officer as and when required. So that is why normally the session court and the high court or session court, they are required to see, inform the accused, you must remain present, go to the police station every week, every Sunday, or whenever the officer informs you. Because the anticipatory bail can only be applied in cognizable offenses. Please note that, not in non-cognizable offenses. It should be an offense where the police officer can arrest you without a warrant. Now, the second condition, a condition that a person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing the such fact to the court or to him. So the court may impose a condition that you are not going to contact any of the witnesses or induce them that tum apna statement palti maro, I will give you 1 lakh. I will send you for excursion to foreign country. I will make your family happy. This kind of inducement or promises, you are not supposed to meet it. The court लिख देता है. Your bail is being granted to you subject to a condition that you will not be meeting any of the witnesses. Isn't it? That condition is now valid. Now, third condition, that a person shall not leave India without the previous permission of the court. So deposit of your passport in the court is permitted now. But whenever you want to go out of India, you can take the permission of the court. Please release the passport. But in Menka Gandhi's case, the passport was surrendered completely. The court did not like it here. 78 case, that was the landmark judgment of the Supreme Court, where Menka Gandhi wanted to travel abroad. The central government suspended her passport, cancelled under Section 10 of the Passport Act. The Supreme Court said that right to travel is a fundamental right within the meaning of Article 21 of the Constitution. You cannot suspend anybody's passport. It is a violation of a right under Article 14, 19, and 21 of the Constitution. Due procedure established by law, or due process, as the American law says, has not been complied with. The principles of audi alteram partem or natural justice have not been complied with. So that judgment is applicable here. But a condition can be imposed here while granting bail, that you cannot leave India, go abroad without the permission of the court. Why? Because many people go away to foreign countries where India does not have extradition treaty. Now, India, the earlier CRPC, the police officers in India cannot investigate the crime outside India. Now, fortunately, now the present IPC covers the ground that year. A commission of the crime committed outside the territorial water of India can be investigated now. That when I am dealing with IPC, Bnss, I will tell you that provision, that is provided that the laudable objective. That is, they can be somebody. Suppose an offense has been, conspiracy has been hatched in a foreign country, that fellow can be investigated. Foreign country के अंदर भी the police officer can go and examine the witnesses. that can be brought back here. So it is easy for the police officer. Of course, there is the extradition treaty with the foreign countries. Many countries don't comply. See, despite the fact that India has got an extradition treaty with the UK and America, many countries, the accused persons are not being sent here. They hold lambas trial. They have their own system. For example, people like under the economic crimes, many of uh, the economic joints have been arrested. Cases are going on against them. India has applied for an extradition treaty, but they obtain a stay order. No, they under the law in England, the magistrate has to pass the order. Then the appealable order before the appellate bench. Then the matter will go to the High Court. Then the matter will go to the Law Commission in the Supreme Court. Everywhere, that's a very lengthy procedure.
So, is there a particular reason that they all go to England? Is there some advantage of going to England, sir?
It must be a cozy country.
And sir, I had a question for your earlier point, sir. I had a question that it's well known, sir, that if the person accused does not, his friends and relatives try to influence the witness. So, are there any provisions being made so that doesn't happen?
Yes, there's a provision. The bail, that you are not supposed to do that. One of the 482 condition is that here condition you cannot indirectly or directly make any inducement, threat, or promise to the any person acquainted with the case. 482 subclause 2 and Roman 2 can the condition they give. That has been the condition that is there now. The other condition is now here. Such conditions may be imposed under subsection 3, 482 as the bail were granted under this section. So wide discretion is granted to the High Court and a session judge while considering the prayer for anticipatory bail in the matter here. So these are the notable changes here. Now, then provisions. Now, by virtue of subsection 4, the rapist, the rapist cannot apply for anticipatory bail. Earlier, this was not there. It's a new section. That is now section 65 of the Bharatiya Nyaya Sahitya. That is 367 tha pehle, 65 and section 70. A person involved in gang rape, where the punishment now is prescribed is 20 years minimum, or to the remainder of his life. Now, no anticipatory bail for rapist. Please note that here. If your client is involved in rape,
so this is true only. So this is only true for anticipatory bail. You can still get bail.
Yeah. Other provisions may you can apply that the strict conditions are imposed. Anticipatory bail you cannot apply. This is subsection 4. See, nothing in this section shall apply to any case involving arrest of any person, accusation of having committed offence under section 65, subsection 2. That I will read it for you. Section 65, subsection 2 of the IPC, the new IPC, Bharatiya Nyaya Sahitya. That is, if you can open it, we have provided last time the acts. (65)(2). Yeah. 65, 64 is dealing with punishment of rape. 65 is a punishment of rape in certain cases where the punishment is 20 years. See, whoever commits a rape on a woman under 12 years of age, please note that, 12 years of age, shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall be mean imprisonment for remainder of a life, of a natural life, and within. So this gentleman, under the provisions of section 65 subclause 2, mean committing a rape on 12-year-old girl. If he is committing a rape on a 13-year-old, he may apply. There is no bar. 12 years के लिए मना है. And section 70 में देखिए when
sir, do you think this will stand scrutiny in court? This
let us see.
arbitrary 12 years.
Yes, Article 14 of the Constitution. But let us see what is the object behind it. Section 70 में आ जाइए आप of the Bharatiya Nyaya Sanhita, that is IPC. Now, which speaks of a gang rape. It is a newly added section, which I will discuss with you next time. Now, under this section, it says, where a woman is raped, is one more person constitute a group of acting in furtherance of a common intention. Person shall be deemed to have committed the offense, rape, and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years. So, a gang rape, a person committing a gang rape, more than 2 or more persons are supposed to be committing gang rape. So, here this person is prohibited from applying for bail. Yes. So this is a very important, notable exception you must keep in mind. Then special power of the High Court and Session Court to grant bail under the new section 483. 483 is equal to all section 460. 460. Yeah, which section it is? Yeah, 460. No, 439. 439 was the earlier section. 439 is now 483. Sections have been little tampered with. Lawyers and judges will find it difficult, but we'll get used to it. No problem. Now there is
So why
no
has this been done, sir? Why have they tampered with the sections?
Why? Because they have deleted the earlier section. Because even in the year 1973, when amendment took place to CRPC, they have deleted some of the provision, but the section is not deleted. The section was in force. Okay. So they wanted to synchronize probably. They wanted to synchronize to make it everything alphabetically correct. That may be the reason. Of course, this will cause some problem to the judges and lawyers, but we'll get used to it with the passage of time. So there is no change. Yeah, there is no change in section 483, which corresponds to the earlier section 300 section of the 439. Sorry, 439. Remember that 439. Remember this 439. Open it up when I say that. 439 CRPC. Special power of the High Court or a Sessions Court. So there are no much changes here. So these are the important chapters relating to the first information report, then relating to arrest, relating to remand, relating to bail provision. Okay, in the CRPC, which you must remember it here, because as a practicing lawyer, this is what going to be helpful to you. Now, uske alawa, there are a lot of changes which I will discuss. Before that, then I will also like to. What is the time now?
7:30.
7:30.
7:30. So we have 1 more hour's time. So I will now take you through the relevant provisions of the Indian Penal Code, the new Bharati.
Sir.
Yeah. Anybody wants to ask me question, ask. Then before I come to tell you what are the amendments in the IPC.
Sir.
Yeah.
Sir, there were some special penal laws, and they had a different procedure
apart from the CRPC. Now,
Yes.
how these the conditions of the bail were there stringent there on all
Yes.
those
Yes.
all
उसके
the
लिए देख लिए उसके लिए open to section 21L of the new act. Section 21L of the new CRPC, that is a BNNS, Bharatiya Nagarik Suraksha Sanitya. Open section 21, a definition part mein. Your answer will be clear here.
what it provides, sir?
I'm coming. I'm reading it. 21L. It says, new explanation, 21L define that where any of the provisions of special acts as regard investigation are inconsistent with the provisions of this Sanitya, the provisions of special act shall prevail. Got it? 21L. 21L. This has been newly added here. Huh? Please note that that is the answer to your question. 21L. IJKL. Investigation includes, see that here? Investigation के नीचे explanation डाला गया है. Got it?
Yes.
Investigation includes all proceedings under the Sanitya for the collection of evidence conducted by the police officer or by any person other than the magistrate who is authorized by magistrate in this behalf. Magistrate does not conduct investigation. Magistrate holds only inquiries. Investigations are done by the police officer or by any private person also, provided the magistrate directs.
Authorizing.
Under the now explanation says where any of the provisions of special act like Unlawful Terrorist Activities Act, like provisions of MOCOCA in Maharashtra, the provision of any act are inconsistent with the provisions of Sanitya, provisions of special act will be. Special act always override the general law. समझे ना आप? तो एग्जाम्पल देखिए, फैमिली कोर्ट में CPC एविडेंस एक्ट डू नॉट अप्लाई, and even in the cooperative court the provisions of CPC are strictly not applicable because the cooperative court act is a special act. But if there is no provision in the family court or in the cooperative court dealing with a situation, then the CPC will apply. But otherwise, if there is a provision, the special act, the family court act, or the provisions of a cooperative court or any other special law, that law will apply. Now here, under the provisions of MOCOCA, there is a similar, different provision. Special judge will investigate the crime. Unlawful Activities Act. Narcotic Act में NDPS में certain superior police officer not below the rank of DSP will investigate the crime. The investigation carried out without giving intimation to the magistrate are illegal. But यहाँ पे investigation CRPC के अंदर the police officer need not send intimation to the magistrate I am investigating. But whereas under the NDPS Act, it is mandatory, section 50 clearly says that. So that law will, so when there is a conflict between CRPC and the special act will override the general. So CRPC is a procedural law, it's a general act. Understood?
Yes, sir.
Yes. So before I, yeah.
Sir, are you happy with BNSS? What, in your opinion, is the weak point that can be exploited? Please give us your thoughts, sir.
I am only at the moment explaining what they are presented. I have informed you in the cases of remand under the provisions of 167, the new provision. Very unhappy picture is presented. Instead of keeping the accused person 15 days in police custody, it can go to 60-90 days time. So that is a unhappily drafted provision. The gray area in the provision.
Sir, how much of this case? will stand
But
in
there are
court,
also
sir.
good features. Think of the good features. Victim is given a right to be provided with information. First information copy. Investigation to be completed within 90 days. The judges are required to, now they introduce a community service as a punishment in small offenses, petty offenses. So overcrowding of the jail will be eliminated now. So accused ko bolenge, you go to the old aged home and take care of the senior citizen. Go and plant certain trees in public parks for about 1 month time.
Write a essay.
ये सब कराएंगे ना अभी. These already orders have been passed by various court.
Hey,
So-
essay writing, sir.
Writing
Yes.
an essay, he say.
Yes, you can do that. So there are provisions which are plus and minus. Pune case, yes.
Gaurav has to say something.
Yes, anybody want to say anything?
Yes, sir.
Gaurav?
Sir, I have a question. Sir, what will happen to the existing state amendments?
Existing state amendment to what?
Yes, sir. Sir, the amendments which are provided by the states in CRPC, different states have their different amendment.
Now the state will have to reconsider again, reframe it in the light of the Central Act now.
Sir, but I think like just like now you said, the special law will prevail over general law. So
Yes.
that will that happen in case of what Gaurav is saying regarding state amendments?
See, this being a law which is passed under the concurrent list, the state has a right to make amendment in conformity with the main section. They cannot go in derogation with the act itself.
Hmm.
So the constitution provides that here both the state government and central government can make the laws. Isn't it? So we will
True.
take into consideration the positive laws. Yeah, I think now CRPC रखी है अभी, बाद में we further discuss. तो IPC के अंदर जो amendment कराए हैं, I will bring your attention. Give me that IPC notes which we have created. Then we'll discuss later on. Then further amendment will also be discussed. Yeah. Now, all the three bills were brought on the same day, and they were enacted, and consent was given by the president on the same day. That is 25th December. अब तीनों आके ले चुके हैं. Now, maximum amendments have taken place in the Indian Penal Code which is now has been characterized as Bharatiya Nyaya Sanhita. Isn't it? Now, what are the notable amendments? I will draw your attention. Now, आपके पास old CPC है तो रखिए. I will discuss the provision. Open from section 1 say we'll see what are the amendments. What chapters are added? What chapters are deleted? Now, IPC, CPC, CRPC. The new CRPC, the old CRPC has totally 23 chapters. Just make a note of it. And total 511 sections. 23 chapters. 23 chapters. 23 chapters. Get the total and let's see that. Count it. 511 sections, right? 23 chapters. Now the Bharatiya Nyaya Sanhitya, the new IPC has totally 20 chapters. Open this. Bharat Nyaya. It has got 20 chapters and total 358 sections. You should know how to see. Is it above? Yes. This is how it is. Total? Yes. 358 section. Now, what is deleted from IPC? Now, IPC, this one. IPC, nikalo Indian Penal Code. Yahan pe. Now, what is deleted in IPC? Section 13. Kholo up. Section 1(3). That is, what is redundant is Queen. Now, Queen is gone long time ago. Long live the Queen. Isn't it? She is no more required. Rightly deleted. Though she was repealed in the year 1950 under the old code, but the section has been remaining in her memory. The present parliament has correctly deleted, in my opinion. Then 14 को भी delete किया. The section 14 deals with the servant of the government. Though the word servant of the government continued appointed, employed by India or by under the authority of the government. This is also deleted now. Then section 15, British India. Though it was repealed in the year 1937, British India, section was very much dangling. Section delete kar diye. Rightly so. So, section 13, 14, 15, 16 bhi gaya, government. The word government denotes central government and the government. State government ko nahi jata. Yahan pe government of India. 16 government of India. It was repealed in the year 1937. Now, what is not substituted in the new IPC is deleted section 56. 56. Sentence of European. ये भी deleted. Deleted section 56. Sentence of European American to penal servitude. Proviso as to sentence of a term exceeding 10 years. Though this has been deleted with effect from 1949, the section was occupying the place. So probably wanted to synchronize it. They want to bring serially to nikal ke फेंकें. Then 58 भी देखिए आप. Offender sentenced to transportation. How dealt with until transported. Kala Pani, you know that? Many of the Indians were being sent to Kala Pani, that is Rangoon में भेजे थे. Transportation, heavy partition. So transportation is no more a form of punishment. So it has been deleted now. Now, 59, transportation instead of imprisonment has been deleted now. वो भी निकाल दिया गया. 61 and 62, forfeiture of property in respect of offenders punishable with death. Though it was repealed in the year 19, long by the Indian Penal Code of 1921, section was occupying. Sentence of forfeiture of property 61. 61, 62 भी निकाल दिए. Then 124A, sedition. (124A) sedition. In fact, the Supreme Court had suspended this section about 3 or 4 years ago. Because almost every person who raises slogans against the government was being arrested, a journalist. The Supreme Court was granting bails to everybody. And it strongly recommended that this section has become nugatory, useless. It is coming in conflict with your right to freedom of expression under Article 19. So government has thought it fit to remove it. Then 138A, application of foregoing section to Indian Marine Services, though it was deleted, it was occupying the place. It has been rightly dismembered. 161 to 165, those are the offenses relating to public servant. 153 AAA. Punishment for knowingly carrying arms in procession, organized holding, taking part in a mass drill has been now deleted. Now you have a right to carry a kripan, a danda. So there is also amendment to 144A to the CRPC. ये 153 AA निकाल दिया गया है. Then 161 to 165, offenses relating to public servant, that is a gratification. ये corruption act already है अभी, इसीलिए निकाल दिया गया. You know that? Corruption act है and sections were occupying 161 to 165A are rightly deleted, omitted, deleted from the IPC. Section 216B again, 216B, definition of harbor, though has been repealed, it has been kept. They are knocked out from the present section. Then 226, unlawful return of transportation. When transportation itself is deleted, there is no point in returning 226, rightly deleted. 236, 236B. 236, abetting in India the counterfeit out of India of coins. Then you have to see the reason why this has been deleted. 238, import. 237 also deleted. Import or export of counterfeit coins. Maybe they have consolidated into one. 238 is also deleted. Import, export of counterfeit of Indian coins. Then 264, fraudulent use of false instrument of weighing. There is a Weight and Measurement Act. So probably you cannot have more than one act. It amounts to parallel, but double jeopardy will apply, isn't it? You cannot be prosecuted for the same offense again and again. Then 265 is again relating to weight of the measures, fraudulent use of a weight. Weights and Measurement Act may offense abhi hai. Then what section?
267, 266 and 267.
Yeah, 267, 266, 267. Again relating to weights and measure, removed from the statute book. 309, attempt to commit suicide, is now deleted. You have a right to commit suicide. 310, no, thug, ये निकल गया अभी. This is for 309 following the Supreme Court judgment. 311 gaya, 310 gaya. Then 377 unnatural offences is now also removed. 377 nikaliye. Along with the adultery provision, 377 also is gone. Then trademark related cases, 478 is also removed. 478. 478 trademark is dealing with the penal provision. So there is no question of keeping in IPC the similar offences. Then 480 kya kehta hai dekho? 480 use of false trademark. Deleted because when the new Trademark Act covers this provision. Then 492 breach of contract. Show 492.
Sorry, sir.
492 has been deleted. We have to see the reason why. Of course, 497 adultery on account of Joseph Sain's case, Supreme Court judgment, that is removed. There's a 5-bench judgment of the Supreme Court in the case of Joseph Sain's case. That you remember it, yeah. Then total 36 sections have been deleted from IPC. Kitna? 36. And 13 new sections have been added, which I will show them. They have been consolidated into 358 sections now. 13 section naye add kare. What is now added will come to know. Now, naya section open karo. Naya section open kare aap. The new act open kare aap. Section 2 subclause 3 is new. Child definition. Child definition. Child definition. Yeah, 210 mein. Yeah, new definition of a child in 2 subclause 3. Mean a person below the age of 18 years. He is now, even this also, there must also be an amendment probably in the Juvenile Justice Act. Pehle 16 tha, 18 ho gaya ho, Juvenile Justice mein bhi. Then there's a new section in 210, transgender ke baare mein bhi hai dekho. Now let us see section 210 of the new section. The new definition of 210 recognizes transgender in addition to gender of a male and female. Okay, this is in the light of the new Supreme Court judgments, Constitution bench judgment. Then section 4F is newly added. Community service. 4F dekhiye. Section 4F. So there is a new punishment, community service. Section 4 खोलेंगे आप of the IPC, open IPC section, section 4 IPC.
Sir, how the transgenders were treated under the IPC? How they were the IPC was looking towards them?
Under the old IPC, their transgenders were not at all their person. They were not defined. Because now the Supreme Court said they should be given rights, isn't it?
Yes, sir.
The definition refers to transgender and defines the term which was not there in the earlier section 8 of the IPC. So earlier section 8 check करेंगे आप. Section 8 में gender था. Huh? When you see gender का definition, Section 8 of the old IPC, it says the pronoun he and its derivatives are used for any person, whether male or female. इतना ही. But it does not say transgender. It's a third classification, third type of person. Now section 4F check करो आप.
Sir, so then whether it was giving some benefits to them under the earlier IPC?
Under the old IPC,
Sir,
if a case is brought out against them, would be dismissed because there is no such person. Probably they will invoke the provisions of General Clauses Act. Section 4F check करें under the new act. Section 4 that deals with punishments. Yeah, under the old act, this is $5. Under the old act, see punishment to which the offenders are liable under the provisions of the Sanitya, number 1, death, imprisonment for life, imprisonment which is of description, namely rigorous and hard labor, simple forfeiture of the property, fine. F is new, community service. Now, what is a community service is not defined in the IPC, but it is defined in the CRPC. I will take you through. The community service as a punishment for petty offences like non-appearance in response to proclamation. They are defined. Attempt to commit suicide, to compel or restrain exercise of lawful power, petty offences, return of money. Now, it is not defined here. It is defined under section. The term community service is defined. I'll tell you. Section 23 check करें आप इस CRPC का. The Bharatiya Bnss. Section 23. Section 23 का भारतीय नागरिक सुरक्षा संहिता 2023 के अंदर sentence which the magistrate may impose. This is very important. The court of a judicial magistrate may pass any sentence authorized by law except sentence of death, imprisonment for life, imposing term not exceeding 7 years, like the earlier powers. Now, number 2, the court of magistrate first class may pass any sentence of imprisonment for a term not exceeding 3 years and fine not exceeding 50,000 rupees. पहले 10,000 रुपया था. Both or community service. See the word? He has given judicial magistrate first class can impose community service. Now, why the chief judicial magistrate cannot grant? Because he is trying more serious cases. Community service is imposed as a punishment in petty offences. Petty offences are tried by judicial magistrate first class and second class. Number 3 check करें. The court of magistrate second class may pass a sentence of imprisonment on a term not exceeding 1 year or fine not exceeding 10,000 or both or community service. Now explanation defines community service. Community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. So gratuitously, free of charge, he has to perform in petty offences. Small amount punishment which are punishable for worse. ये देखो बंद हो गया. कौन है? So you got the meaning of a community service here. Now, another interesting new section has been added to section 69 in the Bharatiya Nyaya Sahitya, that is IPC, new IPC, I'll call it. Now, section 69 is a new section. This reads as under: sexual intercourse by employing deceitful means, etc. Whoever by deceitful means or by making a promise to marry a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to the offense of rape, because she has been consenting and doing, shall be punished with imprisonment of description for a term which may extend to 10 years and shall also be liable to fine. Explanation add किया गया. Deceitful means shall include inducement, false promise, employment, promotion, marrying, suppressing identity. Now this is a new section. You know that marriage cases, many women have gone to the court of law, police station. I have been raped by my boyfriend or my so and so for the last 3 years, 2 years. He promised to marry me and he has not married. So though the police officers were recording as a rape, but the courts have been quashing it. There is no such provision in the IPC, because you are a person having sexual intercourse with the person whom you are intimately known for the last 3 years, you kept quiet. So it is not a rape. So no punishment can be awarded. So the high courts were quashing the matter under 482 inherent powers. You know that. Now to overcome this lacuna, no, though the act may not be amounting to the rape, but you have made a promise of marrying her, promise of giving promotion if you are her boss, or some inducing her through deceitful means, and you are satisfying your lust by A reason, B reason. So specific new provision has been added. Now in this section, he can be punished now for 10 years. This is one of these significant changes, new section which is brought about. Now, the person promising to marry has to be careful. The bosses who give punishment have to be careful.
Sir, is this right?
Now, time
I mean,
8 o'clock. Shall we stop it here, or shall we continue, or shall we what? Tell me now. Subject to your
stop,
approval.
sir.
We can stop it. Yeah. No, other provision will cover in next lecture.
So one question, sir.
Yes.
Sir, is this 10-year imprisonment justified, sir? How will they know what happened behind closed doors, sir? This will again lead to harassment, sir.
But there are many girls who have been cheated, no? They have been given false promises. A gentleman is, you know.
Yeah, but sir,
committing the act of, under the guise of marrying, yes.
Any intimacy, sir, for promotion, sir? What is happening, sir?
You should not make false promises. Under the garb of false promises, you cannot be misusing the woman, you know.
Sir, but isn't any act tainted with immorality? They will then give judgment based on what, sir?
No, immorality, it is an intercourse, sexual intercourse. The word is used.
Yes, sir, but the whole act of giving promotion in exchange for sexual favors is immoral, no, sir?
Yeah, it's immoral. There was no specific provision for punishment. Now punishment has been awarded. 10 years time. Let us see what does the Supreme Court says on this point. Of course,
Sir, I have a question.
The act is yet to come in force from the 1st of July 2024. then uske baad many writ petition which are already filed will decide the fate of the act. And according to me, the Supreme Court will not interfere with many of the sections. Yes, Gaurav, you have
Thank you,
any
sir.
question?
Sir, burden of proof will be on whom, the girl or the boy, to prove this offense?
Naturally,
Boy,
if the
I
girl,
think.
if the girl has said that I have gone, there is a provision under the Indian Evidence Act that consent is due. 114 A and B check karo aap. Absence of consent need not be proved by the girl. Evidence Act में amendment हुआ ना उसके अंदर. Open section 114 A and B of the Indian Evidence.
Sir, but there is no, but there is consent is not given in this section 69. Consent is not mentioned.
Yeah, either here by consent only, no. The sexual it's an this particular sexual act take place with consent. But what is relevant is here, you are given promise to marry. Whether the promise to marry was given was important.
But the consent is already given in this section. Girl had already given her consent.
Consent is given because you promise to marry. You promise to promote. Of course, that evidence, she has to discharge a burden. Marrying aspect. That boy will take up the plea. I never promised at all.
Okay, sir.
समझे ना आप?
Yes, sir. Thank you, sir.
Then yes, then we'll take the next lecture. के अंदर we'll announce when I be taking. Then other amended sections are interesting in the IPC, which we'll read along with the CRPC and also Evidence Act. Then I will tell you what are the changes brought both in the IPC and in the Evidence Act. Then we'll read all the three acts together. As a practicing lawyer, how the three acts should be put together. CRPC, CPC, Evidence Act. We'll come to know the broad changes which are brought about. So deleted sections you came to know, and some of the amended sections you came to know. Okay, next section. Anybody has any more question before we wind up?
No, sir.
No. Okay. Good night, everybody. Have a nice weekend. Okay.
Thank you, sir, for a wonderful
Good night,
lecture.
sir.
Thank you, sir.
Thanks a lot, sir. Good night, sir.